The offices of the United States Trade Representative for the 2014 Special 301 public hearing. My name is Susan Wilson. I'm Director for Intellectual Property and Innovation here at USTR, and I'm also the chair, not chairman, just chair, of the Special 301 Subcommittee of the Trade Policy Staff Committee. It's the Special 301 Subcommittee, or committee as I'll refer to it going forward, that actually conducts the Special 301 annual review. As I said, today is Monday, February 24th, 2014. The hearing today is scheduled to go until 1:10 p.m. I understand you can't hear. Is that better? You hear in the back? No, no hearing in the back. What about this? A little bit better? I love technical difficulties. Okay, raise your hand if you can hear. Can you hear? Okay, all right, good. This is the first time in my life I've needed 2 microphones, just so everybody knows.
You have 3, actually.
So I have 3, okay, in stereo. Interpretive dance to come later. So we will do our best to stay on time. As you can imagine, with things like this, things happen. So I'm going to ask for the support and cooperation of my co-panelists and for the presenters today to help us end as near to 1:10 as possible. As I mentioned, the hearing is taking place at the offices of the United States Trade Representative. Both a transcript and a videotape are being prepared of today's proceedings. Both of those will be available free of charge at ustr.gov within 2 weeks of today's date. Before I go any further, I'd like to ask my co-panelists and committee members to introduce themselves, please, and speak up. Go.
I'm Damon Dubord. I'm with the Intellectual Property Enforcement Office at the State Department.
Good morning, everyone. My name is Matt Lamberti. I'm with the U.S. Department of Justice.
Good morning. My name is Emily Blymond. I'm in the Office of Global Affairs at the Department of Health and Human Services.
Good morning. My name is Omar Karawa from the Department of Agriculture.
Good morning. Andrea Cornwell with the U.S. Department of Commerce.
Joellen Urban with the U.S. Patent and Trademark Office.
Hi, good morning. Maureen Pettis from the Department of Labor, Bureau of International Labor Affairs.
Good morning. Maria Strong with the U.S. Copyright Office.
Great, thank you, everyone. A bit of a logistical note before we begin. It appears that we have reached maximum capacity for fire code purposes and are at risk of being shut down by the DC Fire Department. No, that's an exaggeration. But I would like to invite my U.S. government colleagues who are not on the panel, panelists who have to stay, to please make room available for our private sector and other guests. So if you are with the U.S. government, I would like to ask that you please step outside until, unless and until some of our guests leave the room. Please. Thank you. Apologize for that. So today's hearing. So today you'll hear from interested parties, private sector, civil society, and foreign governments who responded to USTR's January 3rd, 2014 Special 301 Federal Register notice requesting public comments for the Special 301 process this year. All of those public filings are available at regulations.gov, docket number USTR 2013-0040. The purpose of today's hearing is to provide the committee with additional information that we can use in our deliberations. Those deliberations will lead to the publication of a report to Congress, and that report will be provided to Congress and the public on or about April 30th of this year. This year we received filings covering over 90 countries and addressing the usual dozen or so issues. For the benefit of those today who are here today and those who may be watching the video at a later date who are not familiar with the 301 process, I'd like to take a few moments to go into some background. The Special 301 report that I mentioned is the result of a congressionally mandated annual review of the state of intellectual property rights protection and enforcement in trading partners around the world. USTR conducts this review pursuant to Section 182 of the Trade Act of 1974 as amended by the Omnibus Trade and Competitiveness Act of 1988 and the Uruguay Round Agreements Act. And if anyone can say that 3 times really quickly, correctly, I will give you a quarter. The provisions of Section 182 are commonly referred to as the Special 301 provisions of the Trade Act, and hence the Special 301 report. Specifically, Section 182 requires USTR, through the committee, to identify countries that deny adequate and effective protection of intellectual property rights or deny fair and equitable market access to U.S. persons who rely on intellectual property protection. The statute requires USTR, through the committee, to determine which, if any, countries should be identified as priority foreign countries. The Act's policy or practices that are the basis of a country's identification as a priority foreign country can be subject to the procedures set forth in Sections 301 through 308 of the Trade Act. In addition to the statutory designation PFC, USTR created the priority watch list and watch list categories to assist the administration in pursuing the goals of the Special 301 provisions. The review is conducted each year by a USTR chaired interagency Special 301 subcommittee of the Trade Policy Staff Committee. The review is driven by stakeholder contributions and the contributions of Washington-based agencies and our embassy personnel overseas. So if anyone is interested in reading more about what I've just said, or about any trade issues in general, you can visit the USTR website, ustr.gov. The format of today's hearing will be as follows. Each party has been allotted no more than 10 minutes. We've asked them to spend 7 minutes on prepared statements and allow the committee to ask questions for 3. However, as you can imagine, in a setting like this, there has to be some flexibility in there. I will be watching the clock and will interrupt speakers with different time cues. However, the panel will hold all questions until the presenters conclude their prepared statements. In some cases, we've prepared questions based on the written submissions that preceded today's hearing. In other cases, we'll be responding to the verbal testimony today. I would like to note that there is a post-hearing comment period that is available to the people who are testifying today. Whether if you would like to provide additional information in response to some of our questions or somehow supplement the answers that you've given, or if you cannot address a particular question today but would like to do so after, you have until 5 p.m. on March 7th to file the additional information. I would, however, encourage you to file that information as quickly as possible so that we have an opportunity to review it and follow up in advance of the beginning of our deliberations. As I said, we're scheduled to go to 1:10. We will have a short break at 11 a.m. to allow the transition between the government speakers and our private sector and NGO panelists or presenters for the afternoon. So, without further delay, I would like to recognize the government of Bulgaria. Thank you very much for being here today. We look forward to your testimony. Please get us started.
Ma'am, I'm sorry, we have an identification from each person.
Yes, so the transcriber has requested that each person who sits at the table please identify yourself and spell your name before you begin. Thank you.
Thank you, Madam Chairperson, dear hearing committee. My name is Krasin Dimitrov, Krassin Dimtrov, and I'm a Deputy Minister of Economy and Energy of Republic of Bulgaria. Thank you once again for the opportunity to present my country in front of this hearing. Bulgaria appreciates the United States recognition of the positive steps that our country has taken to address the IPR infringement in its domestic market. This is a continuous process, and we invested serious interest in improving respective legislation and enhancing institutional framework for enforcing judicial adjudication. The USTR Special 301 for 2013 identifies 4 areas of U.S. concerns regarding intellectual property rights infringement for which Bulgaria is on the watch list in 2013. The first area of concern is the internet piracy, which is a global issue and threat to global prosperity. It needs a systematic solution through collective coordinated actions of all countries. Bulgaria will seriously consider joint actions aimed at better IPR protection in this regard. During 2013, our attention was focused on enhancing control over many online services potentially infringing intellectual property rights, enlarging the number of stakeholders on the Council on Intellectual Property Protection, and improving coordination of activities among individual institutions, tightening penalty measures for internet piracy. By doing this, we have achieved the following results. Identified and sanctioned 8 infringements of IPR in 2013, registered positive trend on successful operations of organized cybercrime unit under the State Agency for National Security in the fight against cybercrime and software piracy. And in that regard, we have over 40,000 Bulgarian legal entities which were given warning, discontinuing access to 3 websites which provided unlimited access of internet users to protected music, and identified location of Zamunda.net website, which was cited in the report in Switzerland, and the administrators of the website were ordered to immediately stop access to torrent files that were infringing IPR. Currently, our government further took steps for resolving internet piracy by proposing new penal code, which is aimed at increasing sanctions. We propose new Chapter 9A, Computer Crimes, engaging criminal liability for the providers of internet connectivity in the cases of illegal instigation and supporting the exchange of illegal content via internet. The amendments also include changes in the Penal Procedure Code, aimed to facilitate and accelerate investigation of crimes against IPR over the internet and improve legal procedures in full compliance with the industry requirements for a better and wider scope of application and stricter sanctions and higher fines. The second area of concern is bad faith trademark registrations. Here it is important to know that as regards prevention of false trademarks registration in the Bulgarian and other markets for the purpose of subsequent extortion of the true holder of the trademark, the Patent Office, Bulgarian Patent Office, is not the competent body that could prevent such a practice. The holders of rights are the persons that should take care for the protection of their rights and follow policies in registration of trademarks on the territories of all countries where they have business interests. Bad faith trademark claim can be proved only by court procedure, where court order can ask Patent Office to delete bad faith trademarks registration. The country cannot create legislative or other conditions to prevent or eliminate such unfair practices. The third area of concern are the court case examinations. In the first half of 2013, for which we have contemporary statistics, were examined in total 110 cases, of which 85 cases were closed, where 15 cases by conviction and 70 by agreement. The Supreme Prosecutor's Office of Cassation in first half of 2013 in regard to intellectual property rights protection convicted 99 persons, of which 5 persons for infringement of copyright and neighboring rights, and 94 persons for peace infringements of industrial property. And the last fourth area of concern, difficulties in enforcing collective rights through administrative or judicial action, are no more different from any other debt collection in the country, especially after the global financial and economic crisis that resulted in filing of multiple enforcement cases in court system, which caused delays in all proceedings. We attach utmost importance to increase of the capacity of prosecutors, investigating magistrates and penal judges on proceedings against intellectual property crimes by providing adequate, knowledge transfer and best practice exchange programs with U.S. magistrates. It is important that priority is assigned to IPR case proceedings. Bulgaria recognizes certain weaknesses in the existing legislation, both procedural and penal, and in this regard, as I said, we have submitted in Parliament on January 31st, 2014, the new penal code for public discussion dialogue with business and consumers. And my final statement, dear members of the hearing committee, this past year Bulgaria worked on implementing the specific recommendations of the US government highlighted in the 2013 special report. All stakeholders focused their efforts on internet piracy, bad faith registrations of trademarks, and difficulties with collecting royalties by companies conducting collective management of rights. During 2013, the Bulgarian government paid special attention to protection of intellectual property rights, copyright, and industry property. We feel strongly that increasing the public awareness, changing public attitudes, and stepping up the efforts to enforce the intellectual property protection will enhance the country's international reputation and will provide basis for increase of investments and will help improve Bulgaria's trade relations with the EU member states and the US. We want further to strengthen our growing political and economic cooperation with the US. We appreciate the US continuous support to our efforts for better protection of IPR, and we hope to see Bulgaria taken out from the watch list. Thank you very much.
Thank you very much, Deputy Minister. Thank you for joining us today, and thank you for your testimony. Obviously, there's a lot there to be encouraged by. We are particularly encouraged by your willingness to continue the dialogue with us. In particular, we are interested in exploring the idea of an action plan with Bulgaria going forward to addressing some of the remaining issues. I know that my colleagues have questions, so why don't I turn it over to them?
Thank you. We commend the Bulgarian Ministry of Culture and the Ministry of Interior for the government-led masked software compliance campaign in early 2013. We understand that both ministries sent a joint letter to approximately 20,000 local businesses, informing them of the risks of software piracy and encouraging auditing and compliance programs. We understand, however, that the planned intensive follow-up by the authorities with enforcement capacity has not yet happened. Would you please let us know if and when the Bulgarian government plans to resume this important campaign by engaging in follow-up activities that were planned for last year?
Thank you very much. In this year we have 4 planned sessions of our intergovernmental committee, which is chaired by the Minister of Culture. I am a member of that committee. We have enhanced this committee by introducing more regulators from the telecom and TV regulators, from customs office, and etc. And it will happen definitely this year. And I would like also to state that in terms of software copyrights, our government looks on this area as a priority issue. We have already voted 20 million leva for innovations. Most of them will go for software development. Currently, my ministry has about 600 million for financial grants for development of software applications, and European Union provides access to 88 billion euro funds in this regard. So this is the ICT sector is a priority sector for Bulgaria. It is a sector where we have 30% growth on an annual basis and zero unemployment rate, and we will make anything to be sure that all copyrights, especially for this sector, are maintained in the utmost possible way. Thank you.
Dobar dan.
Dobar dan.
We understand that during the summer of 2013, just last year, Bulgaria's new government moved the cybercrime unit from the Ministry of Interior's General Directorate to Combat Organized Crime, or GETABOP, to the Independent State Agency for National Security, or DUNS, and then transferred the unit's cases to regional police forces. As far as we can tell, as a result of this move, the cybercrime unit is now inactive. That is truly unfortunate, as the cybercrime unit, under the leadership of Yavor Kolev, was truly a bright spot of IPR enforcement in Bulgaria. In fact, with limited resources and personnel, the unit not only conducted some of the biggest and most successful enforcement operations within Bulgaria, but also the entire region. We understand that the cybercrime unit may resume its activities this year, in early 2014. Could you provide us with an update on whether the cybercrime unit is now active, and if not, when it will resume its activities?
So thank you for the question. I will start backwards from your last question. Actually, this report that we filed with the USTR for the Special 301 was possible to be submitted by the help of Yaro Kolev and his institution from the cyber crime unit. And we are working closely with him. As I told you, we have now a new intergovernmental committee where we have a lot of institutions involved. So in particular, the alleviation in movement of the General Directorate of Organized Crime to the National Security Agency was promotion of these special units, including in that regard the cybercrime unit, because now it's an independent agency with much more bigger budget and powers, and they can do a lot in order to improve the business environment in regard to IPR. And definitely it will happen this year. Whether it will be the first quarter, next month, I don't know. But we would like to see it happening before end of April. Thank you.
Okay, we're out of time, unfortunately, for the Bulgaria segment. We would, however, we have 2 or 3 other questions that we would like to ask, so we will submit those to you in writing, and we'll have 2 weeks to respond. So thank you very much for your time today. Obviously, very important issues raised, and look forward to continued progress. I really appreciate your coming today.
Thank you for giving me the floor. Thank you.
Thank you. So our next presenter is the Government of Italy.